In light of the controversy surrounding Claudine Gay, the president of Harvard, one would have thought that Harvard and their graduates could not do anything more to embarrass themselves. And then along comes anti-gun judge Frank Saylor of the United States District Court for the District of Massachusetts, a Harvard grad himself, who managed to turn to Claudine Gay and say, "Hey Claudine, hold my beer. Watch how I box up this gun ban case in a long decision that screws up all of the Supreme Court precedents, demonstrating that either I don't know how to read or I don't care what the Supreme Court says. Either way, it's a no-go and no good." Stay tuned. We're going to break down Judge Saylor's decision upholding Massachusetts AR-15 ban in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and a nominee for 2 separate categories in the Gundy Awards for 2024, Top Male Influencer and Top Voice of the Second Amendment. I'm honored to be nominated in both categories. All right, folks. Breaking news out of the United States District Court for the District of Massachusetts. Chief Judge Frank Saylor of the United States District Court for the District of Massachusetts. Judge Saylor, a former court member, a former judge on the FISA Court. You know the FISA Court from the Russiagate scenario and the scandals. You know the FISA Court that says, hey, sure, it's okay if the intelligence communities spy on and surveil American citizens as long as we, the FISA Court, can secretly sign off on it. Well, that's right. Well, Judge Saylor, who just issued this decision we're going to talk about involving upholding the bans on AR-15s and magazines that hold more than 10 rounds in Massachusetts, Frank Saylor was on the FISA Court for many years. Prior to that, he was a federal prosecutor. Sounds like deep state pro-government to me, doesn't it? Nevertheless, let's carry on. So it turns out that Judge Saylor has decided to take it upon himself to rewrite the law involving gun ban cases in America, ignoring the fact, even though he gives it lip service, that the U.S. Supreme Court has already set forth the methodology for determining how you assess a gun ban case, which of course banning an AR-15 or guns that hold more than 10 rounds with or without fixed or detachable magazines. These have already been decided by the U.S. Supreme Court in 2008 in the U.S. Supreme Court decision of Heller versus the District of Columbia. Nevertheless, Judge Saylor doesn't seem to care. So let's just start right off the top, how he obviously messes this up in his decision to deny a motion for a preliminary injunction brought by the plaintiffs Joseph Capon and the National Association for Gun Rights. How does Judge Saylor manage to get around the Heller case? Well, he makes the most fundamental, gross mistake one can make. The sort of mistake that if Judge Saylor worked for me as an associate, I would fire him from any of the law firms I worked at. This mistake that I'm about to describe would get him fired, in my opinion, at a law firm where I worked at. And I worked at good law firms. We had high standards, extremely high standards. And I'm telling you, this would be a no-go if a brief like this or a memo came across my desk drafted by Judge Saylor. Specifically, if you look at it, I'll put a link to his opinion down below. He puts on page 19 of his opinion, this is what he says. And you who watch the Four Boxes Diner are going to know how he made this mistake. He has a section here that says basically he gets to ignore the Supreme Court precedent. So he says, because AR-15s and magazines that hold more than 10 rounds present dramatic technological changes and or unprecedented societal concerns. Now, of course, there's a very handsome YouTuber that nipped this argument in the bud 6 ways to Sunday in the Harvard Journal of Law and Public Policy. And, of course, that scholarly work setting forth how to apply it in the context of gun ban cases does not make its way into Judge Saylor's opinion. I wonder why. You'll see why, I think, in a second. Specifically, what Judge Saylor says is the Bruin Court directed that when, listen carefully, when, quote, a challenged regulation addresses a general societal problem that has persisted since the 19th century, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. It then goes on to say, however, where there have been, and this is Judge Saylor quoting the Bruin case, quote, unprecedented societal concerns or dramatic technological changes, a more nuanced approach may be required. He quotes language accurately out of the Bruin decision. But do you know what he fails to do? He fails to cite and quote the entire language out of Bruen. He leaves out some language. What language did Judge Taylor decide to leave out? And might it be relevant to deciding an arms ban case, which again, a ban on AR-15s or magazines that hold more than 10 rounds are arms ban cases. Well, here's the part of the clause from Bruen that Judge Taylor conveniently omitted quoting or referencing in his opinion. Let's see if it matters. The full quote from the Bruen decision by the Supreme Court is this, quote, while the historical analogies here in Bruen and in Heller are relatively simple to draw, comma, other cases implicating unprecedented, So he starts talking about this language on page 19, starting with the words unprecedented societal concerns or dramatic technological changes. But he leaves out of his opinion the clause that modifies this. You know, that clause that says, while the historical analogies here, which is in Bruen, and in Heller, a gun ban case, are relatively simple to draw, other cases implicating unprecedented social change, and so on might require more nuance. But when you're dealing with a ban on AR-15s and magazines that hold more than 10 rounds, it is an arms ban case. It is a Heller case. And this language he's trying to use to get around and give him an excuse, a pretext, if you will, to ignore Supreme Court precedent as an inferior court judge, as defined by Article 3 of the U.S. Constitution. An inferior court judge is what Judge Taylor is, not just constitutionally and textually under Article 3. I would argue in other ways and other meanings of the word inferior as well, as best illustrated by the fact that he does not, either on purpose or out of ignorance, refuses to cite the entire law. The law he doesn't cite and quote specifically says that Heller governs gun ban cases and that other cases, i.e. cases other than Heller, i.e. other than gun ban cases, you can talk about these unprecedented changes. But of course, that is not what he quotes. Why is that? Because he knows that it destroys the essence of his entire opinion here that goes on for 38 pages. Pathetic. You get your butt fired if you work for me at any of the law firms I worked at. And I've worked at some of the best law firms on the planet. You get fired, in my opinion, if you did this kind of work. Shoddy work. And a Harvard grad, no less. Again, you thought Claudine Gay had issues? I'll tell you this. Like I said, I think Judge Taylor turned to Claudine Gay and says, you think that's bad as a Harvard grad? Here, hold my beer, Claudine. Watch what I do, in my opinion here, in the Capon versus Campbell case involving AR-15s in Massachusetts. All right, but let's carry on. Now, the second thing is, he says, well, then he goes on, of course, getting the law wrong is the first problem. But then he goes on and misapplies the law. He goes on to say, well, I find that these mass shootings and these AR-15s are indeed unprecedented technological and societal change. That it is unprecedented. BS. Very simple. 2008, U.S. Supreme Court decides the Heller case. What happened in just 2007? We're not even going to go beyond that. 2007, before the Supreme Court decided Heller, the Virginia Tech shooting. And what was the Virginia Tech shooting? Something like 30 people were killed by a student using semi-automatic handguns with magazines that held more than 10 rounds. 2007. So how is it that in 2008, the Heller decision is decided, laying out the methodology for deciding gun ban cases, and then the Bruen case is decided in 2022, all with the hindsight of the Virginia Tech shooting, at a minimum in 2007, of a semi-automatic pistols being used with large, quote-unquote, large-capacity magazines to shoot dozens of people at Virginia Tech. Obviously, whatever the Supreme Court is referring to as unprecedented technological or unprecedented societal changes has nothing to do with mass shootings. Because in 2007, you had one with magazines and a semi-automatic pistol, and magazines hold more than 10 rounds. So whatever you want to say is unprecedented societal change or technological change, it cannot be mass shootings that occurred with semi-automatic pistols or magazines of more than 10 rounds. Cannot mean that. Because in 2007, it was all done. That was raised specifically to the U.S. Supreme Court in the Heller case in the briefing. The Heller case decided and analyzed the Virginia Tech shooting in the context of the Heller decision and issued the decision of Heller, which is supposed to apply as the text that Judge Saylor specifically omitted in his opinion. All right, that's the first thing. Beyond that, of course, we also know, just as a practical matter, that mass shootings go back to the beginning of the time, to the beginning of the Founding Fathers. The Boston Massacre was a mass shooting in lower Boston, right, the heart of Boston. 8 Americans were killed in the Boston Massacre by British soldiers. We know that there were school murders. Enoch Brown, Pennsylvania, was the schoolmaster who was massacred by Indians along with every student in his schoolhouse before the American Revolution. So to say that mass killings and mass shootings were unknown to the Founding Fathers before they enacted the Second Amendment is to ignore history. But again, you don't even have to go back to the founding of America, because the 2007 Virginia Tech shooting right before the Heller decision is all you need to know. And most importantly, what you need to know is the Bruin decision textually points out that Heller is not a dramatic technological change case or unprecedented societal concern case, because it specifically says, again, the historical analogies here and in Heller are relatively simple to draw. Other cases, i.e. cases other than Heller's gun ban methodology or rule of law, may get into this. But nevertheless, Judge Saylor simply ignores all of that. Terrible, terrible reasoning, in my opinion. But let's go on to see some of the other mistakes that he made. The next thing is, of course, let's just assume for the sake of argument, that Judge Saylor is allowed to ignore the Heller decision, which, of course, just simply says that the only conceivable theoretical basis for banning a gun of any sort, a class of firearms of any sort, is that if somehow the government can show it's somehow dangerous and unusual. And, of course, everything we're talking about here, AR-15s and magazines of homeward 10 rounds, are ubiquitous. That's why the anti-gunners want to ban them, right? You look at any literature from the anti-gun lobby, they're like, we have too many weapons of war. We have too many AR-15s on the streets of America. We have too many magazines of homeward 10 rounds. We need to stop all this. Well, of course, if these were not commonly owned and ubiquitous, they wouldn't care about them because they would be around. No one would have them. They wouldn't care. It'd be a non-issue. So it's almost like that the anti-gunner arguments about these things demonstrate the point that these are ubiquitous. These are in common use for lawful purposes. But again, the next thing that Judge Saylor does here, of course, is he has to try to find historical. So let's assume that Heller is not the law of the land, and you actually have to look for historical analogs. Now, for a historical analog law, now remember the way it works. If you get outside of the context of a case like Heller, where you've already decided how gun ban cases work, but let's just play out the methodology for the sake of argument. You start with the text of the Second Amendment. Well, the text of the Second Amendment, as you know, says the right of the people to keep and bear arms shall not be infringed. What is an arms? Well, we know what arms are. The Heller case defined it as anything that can be used offensively or defensively. Obviously, an AR-15 or magazines can be used offensively or defensively, therefore they're arms. Once their arms are satisfied, and here you have a ban on a type of arm, means you're implicating the right of the people to keep and bear arms because you're banning a type of arms. Okay, now the burden shifts. The burden shifts to, guess what? The government, to come forth with historical evidence, historical analogs to show that you have a historical basis in American law for banning guns. But guess what? The analogs that the judge comes up here are all analogs of gun regulations at best, like Bowie knives, okay? But Bowie knives are Bowie knives. There was no bans on these things. There were some restrictions on whether or not you could carry these open or concealed, and the like. But again, there is no historical analog law that bans these kinds of weapons anywhere in American life. Certainly any kind of weapon that is in common use cannot be banned, because it was weapons that Americans used for their common lawful purposes in their farms and their homes that they would use to bring with them to militia musters. So therefore, the Supreme Court in the Miller case in the 1930s and the Heller case says, well, obviously, any arm that's in common use by Americans today is obviously protected, because those are the kinds of guns or weapons or arms that they would bring with them the militia muster, and that's the sort of thing that would be protected today. And again, the way it works is the text says arms are anything that can be used offensively or defensively, burden shifts to the government, and then the history is that's where history comes into play. And this is the next fundamental mistake that Judge Saylor makes. Again, if you look at the historical analogs, remember the Supreme Court did exactly the methodology of Bruin and Heller. In Heller, they looked at the text of the Second Amendment. They said, obviously, handguns are protected arms under the Second Amendment's text. They then said, let's take a look at the history. Is there any historical regulations or any longstanding tradition of regulating these kinds of guns, i.e. a gun ban? They said, the only conceivable historical analog that might conceivably apply here is a history of banning the carrying in public of dangerous and unusual weapons. They said we don't need to get into the delimiting or defining the full scope of that. All we need to say right now is that whatever it means is if the American public has chosen a particular type of firearm so that it's in common use by Americans for lawful purposes, it simply cannot be banned because it cannot fall conceivably within that theoretical ban on dangerous and unusual weapons, because if an arm is commonly owned by Americans for any and all lawful purposes as a matter of history, then guess what? Can't be banned. Can't be banned. Okay? So that is clearly what the law says. But of course, what this judge is trying to do by signing to just a handful of regulations, he basically skims over it like a couple sentences. He doesn't do any real analysis. And the reason why his historical analogs don't work is for the same reason why the Heller Court found that there was no historical basis in the 18th century for banning any kind of commonly owned gun or farm. And that is because if you look at the historical analogs in American life, you do not see gun ban cases until really the 20th century. But as you know, because we're trying to interpret the 1791 effectuated Second Amendment, the text of the Second Amendment has to be understood at the time it was adopted in 1791. It doesn't matter what a 20th century person like FDR thinks about the Second Amendment. It's what at the time of the founding do the people that adopted the Second Amendment, what were they understand this to mean? And whatever it was, there's no gun bans until the 20th century. And therefore, even if you looked at all the historical analogs now, what you really would be doing is replowing the exact same historical analog law work that Heller did in 2008. You can replow that ground, but guess what? You're going to find the exact same conclusion and reach the same conclusion, if you're intellectually honest, that the court did in 2008, which is there's simply no historical basis in American life for long-standing gun bans of any sort. We just didn't ban guns. Again, we maybe would restrict how you carry them. There were, again, whether open or concealed, there was some of that going on, perhaps. Maybe some products liabilities protecting you from things blowing up in your face, perhaps. But none of it had anything to do with banning guns for the purposes of some sort of crime control. That did not occur. In fact, again, if you look at the regulations, whenever there was a danger in society, like in a church or some other place they feared could be attacked by, let's say, the marauding Indians, guess what? The founding fathers went the reverse. They required Americans to bring guns. They did not put up a gun ban or a no guns allowed sign. They required people to bring guns. So the founding fathers, the way they addressed these societal problems of crime and violence and mass murders is with more guns, not less. The last point I want to make here, and maybe I'll do another video because there's so many mistakes in here, I may want to do another video here. Just the absurdity of it. Now, how many of you remember that in 2008, if you go back and look at the briefs submitted in the Heller case in 2008, it's very entertaining because the anti-gun movement in that Heller case argued that it was better for Americans to have rifles and shotguns for self-defense than handguns. It was handguns that were the scourge of American life. It was handguns that people used mostly to commit suicide, to commit crimes, and so on. And it was the preferred tool of the criminal class. And therefore, because the District of Columbia in the Heller case had banned handguns, but not rifles or shotguns, the government's position was that we're allowed to ban handguns because they can still exercise their right to keep and bear arms by having rifles or shotguns. So in other words, the argument by the anti-gunner in Heller was handguns bad, long guns good. And then the Supreme Court says, no, you can't do that. That's not a basis. You can't say that one type of gun is good and another type of gun is bad. We the people get to decide the kinds of arms that we choose. And because Americans have overwhelmingly chosen handguns in the Heller case, they could not be banned. And what's amusing, of course, and pathetic, really, is that Judge Saylor goes the opposite direction here, right? Here's what he writes on page 12 of his opinion, quote, handguns are the quintessential self-defense weapon, quoting Heller. Then he goes on to say, it seems likely, therefore, that legislatures, such as Massachusetts, presumably, it seems likely, therefore, that legislatures have some greater degree of latitude when regulating firearms that are not handguns. See? Now, he's saying the opposite of Heller. He's saying, well, handguns are good because they're the quintessential self-defense weapon. Therefore, other kinds of guns must be bad. And therefore, you get to regulate other kinds of guns, even though we know that long guns only kill like a few hundred people a year. All too many, but compared to the thousands of people killed in one way or another with people with handguns, it pales in comparison. And yet here you see a little jiu-jitsu going on by Judge Saylor trying to say, well, yeah, okay, in Heller, handguns are bad and long guns are good, but today, in my case of National Association for Gun Rights against Campbell, I'm going to say handguns are good and long guns are bad. Terrible, pathetic. And that's the kind of thing we're seeing in these kinds of cases. So the bottom line is that Judge Saylor denied the motion for a preliminary injunction. I'll probably talk about some of the other mistakes in a future video, but I think this hits the highlights. Judge Saylor is using this unprecedented societal change or technological change as a pretext or excuse to ignore the Heller case. But he can't, because the Bruin case already anticipated people doing that, and that's why they wrote the language in here. Again, I'll put a link to the Bruin case down below, and Heller, and to this, and you can see if you disagree with me. But in my opinion, this is a terrible decision by the Harvard graduate, Judge Saylor. I think it's an embarrassment. The reality is I don't think he cares. Again, I've told you that all those judges in the United States Court of Appeals for the First Circuit, which includes the District of Massachusetts, are absolutely terrible on Second Amendment rights. So the reality is I expect nothing good to come out of that part of the country, at least in the federal court system. I think there may be some good state laws in places like New Hampshire in the First Circuit, but I can tell you when it comes to the federal court system, they're terrible. And they're just awful, and expect nothing good to come out of there except a basis for appealing to the U.S. Supreme Court from their nonsense. That's the harsh reality of that court, and that's just the way it is. But we will carry on the fight. Okay, folks, hope you learned a little bit something here today at the Four Boxes Diner. Make sure you subscribe and follow me on X at Four Boxes Diner. Again, I should note that sometimes people say they get unsubscribed from this channel. So if you're not sure, please resubscribe. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.